tonight with us. We're so honored to have with us the runoff candidates from the primary last March for the Third Court of Appeals, Place 6. We have Donna Garcia Davidson and Mike Todd. So if you two would like to come forward, well, what we're going to do is we'll give you there's a mic on the table that you two can share, so you can sit there and answer questions, or if you feel you have to get up and move, just remember you're being filmed, so make it easy on Kat there. But we'll give you 5 minutes to make any introductory remarks, lay out your planks, whatever you choose to say. And then we do have questions. We've gathered a few questions now. We expect more to come forward. So I'll read the questions to you, and Roy, what did you decide the time limit would be to answer questions? Was it 2 minutes? Okay. Roy Dean will be your timer there, so he will let you know if you're about to go over. All right, so, gosh, who's first on the ballot? Do we know that yet? If not, we'll go alphabetical.
We have a different ballot order in each of the 24 counties.
Oh my goodness.
Oh.
Okay.
Right. I'm first in about 9 or 10, and I might end up first in several just because it depended how we were on. Do you remember how we were on the ballot here?
I do. I believe you were first on the ballot in Montgomery County.
Okay.
Now, I don't think that microphone is on, so you'll need to turn it on. But Ms. Davidson, if you would like to go first, and then followed by Mr. Toth, and then we'll get into the questions.
Okay, well, thanks y'all for having us. I'm so excited to be here. I'm Donna Davidson, as Lila told you. I am absolutely humbled and honored to actually have made it through to the runoff. I am excited. I think this has been one of the most exciting times of my life, and I have not stopped ever since March 6th. So when Lila kind of hesitated when that was, I never stopped. The very next day I was still campaigning, and I've been on the go ever since. So the things that I want to stress to you, most of you look familiar from one of the last times we were here with the entire, we had a lot of people up here then. But what I want to emphasize tonight is, what I stand for and who I am. A lot of people wonder what the court does and how the court makes decisions. People throw out the rule of law a lot. They throw out judicial restraint, and they throw out the strict construction of the constitutions. I abide by that, but what does that mean? What does that really mean to me? So the rule of law to me means that it is the legislature's job to have the laws, and we've got the constitutions. Constitutions help us figure out if a law is or is not constitutional, because you try to read everything in light of the Constitution. Does it infringe on our freedoms? Is it constitutional? So instead of me trying to figure out if I like a law or not, I just figure out what the law is and then try to apply it. And that's basically what I do for my clients every day. I'm always trying to give them advice. I'm looking at codes, ordinances, statutes, the Constitution, whatever it might be, and they're trying to comply with the law. So basically what I do on a daily basis would be what I would do in a position on the court, and examine it, try to apply it, make sure that it's constitutional, and be brave enough to say if it's not. Right now, I can't just say something's unconstitutional and I want to ignore it. That's not the way it works. We do believe in the rule of law. Whether we agree with the law or not, you still have to obey the law. Some people like to drive 85 and it's a 75. You suffer the consequences for not following the rules of law. And what does judicial restraint mean? Well, that means that if you don't like a law, you don't just try to interpret it the way you want to, because that's what you think should be. The people elected the legislature, and the legislature made the law. The people can change those legislators. They can change those laws through their legislators. It's not up to the court system to do that. And then finally, the strict construction of the constitutions. They are the words that we have been abiding by for many, many years. They're great words. They're words that help us understand that even if somebody runs for a congressional district and doesn't live in that district, the Constitution allows for that. Okay, you might not like it, you might not vote for somebody who doesn't live in the district, but you're not going to change the Constitution or somehow rule it unconstitutional, right? It's in the Constitution, it's okay. But you don't have to elect that person if you don't want to. So that's what I think of those issues. And I want to let you know, I have been practicing my entire career in Texas. I've been licensed for more than 25 years. And I would love and be humbled and honored to serve as a justice on the Third Court of Appeals to represent you. So thank you very much. I'm Donna Davidson.
I'm Mike Toth, and I feel very blessed to be back with you all. It was a wonderful experience when we came for the candidate forum before the primary, and it's even more wonderful to be back with you today. Ronald Reagan many years ago said that we're always one generation away from losing our freedoms. And I believe that it's still true to this very day. We have to be ever vigilant in our country because we have the greatest constitution and we are the most exceptional country in the history of the world. And to whom much is given, much is expected. We have to keep the flame of liberty alive because we are a beacon of hope for the rest of the world. When President Obama was in office, I really felt like the executive branch for our federal government was not applying the Constitution as it is written. The Constitution gives all legislative power to the Congress. And what we saw for those 8 years was a federal executive that was trying to remake the law and not, as they're told to, execute the law. When President Obama issued job-killing regulations like the overtime rule and the persuader rule, I, at the Texas Attorney General's office, defended Texas and defended the Constitution, and we got nationwide injunctions against those rules. When President Obama tried to remove privacy protections from public schools across our country, I, at the Texas Attorney General's office, defended the Constitution and defended Texas, and we got a nationwide injunction there. When President Obama, near the end of his time in office, tried to issue a rule that would have overridden the conscious protections that doctors and medical professionals have, I, at the Texas Attorney General's office, stepped in and defended Texans and defended the Constitution. I have spent my life in public service in an earlier time when, again, our nation's liberty were at threat. After 9/11, I joined the U.S. Marine Corps, and I served on active duty as a lawyer for 4 years. And for the reasons of patriotism, I continue to serve in the reserves, which I do to this day. Obviously, we have a new president, and there's a new set of legal challenges. I have defended President Trump's travel ban, working for the Attorney General side by side.
Can you hear me? I think I probably just talk. Can you hear me?
No? Probably gonna need the mic.
This one will reach over there.
Is this better?
Yes.
Okay, great.
Thank you.
Wonderful. I've also defended federal immigration laws. And recently in the Texas Attorney General's office, we opened up a new legal challenge against Obamacare. All these issues are issues where, front and center, what I've fought for is to continue the constitutional system that makes us the most exceptional country in the world. I have some judicial experience. I spent some time working as a lawyer for 2 different federal judges, one a federal trial court judge, and the other a federal appeals court judge here in Texas. The federal appeals court judge that I worked for was appointed to the federal bench by President Ronald Reagan and confirmed, and is an incredible stalwart. This is the judge who recently upheld Texas's voter ID law, and before that upheld Texas's sanctuary city law. And I'll tell you something about the voter ID law. When that case was argued, it was argued in a federal appeals court. Well, guess what they do when you walk into federal appeals court? What do they ask for? Your ID. I felt pretty good about that one. Walking into a court on a voter ID case where the court asks you if you have an ID. Just goes to show. One other aspect of judicial experience is just a love and a lifelong interest in understanding the Constitution and explaining the Constitution. While I was in law school, I got a master's in history with a concentration on constitutional history, and I wrote a book on an early founding father who was an early Chief Justice of the U.S. Supreme Court. And during that process of research and writing, I deepened my affection for our Constitution. It really is the document that best matches human nature as it is. And that's why we've been so successful as a country. And yet, the Constitution and our heritage, as Ronald Reagan pointed out, is always under threat. I think in the previous administration, we saw a lot of threats coming from the federal executive. Now the battle has moved into the courts. And that's why I got into this race in the beginning. There are 6 members of the Third Court of Appeals. 4 of the 6 are up for election in the general election in November. And I know you're going to hear from some of the justices at your luncheon later on this month. There are 4 Democrat opponents who are lined up. And they would remake that court in a very activist way. I think I have the experience which is responsible for the endorsements I have. It was great to come into San Angelo and see the sign for Senator Charles Perry. He's endorsed me. A number of Tea Party groups, as well as our Attorney General, have also endorsed me. But most important, I'm here to get your support. And I look forward to answering your questions and getting to know you more tonight.
Nope. It's kind of short.
Well, that's going to be awkward.
We'll get our exercise.
Yeah,
We've been sitting in cars all day. This is fun.
flexible. Okay, let's figure this out. All right. The first question that I have, and this is addressed to both of you. So I guess, Mr. Tom, you can answer this first. But the question is, what is the function of the Third Court of Appeals?
Well, I would highlight 2 things in answering that question. First off, the Third Court of Appeals takes cases on appeal from 24 counties, including Tom Green County. So when cases are tried, the parties have a right to an appeal, and those cases are appealed into the Third Court of Appeals. It's very important to note that this Texas Supreme Court, which sits above the Third Court of Appeals, does not have to take any appeal. And the reason for that is there's just not enough time, there's not enough justices, there's not enough bandwidth for the Texas Supreme Court to be taking every appeal. So it's very important when you think about the courts of appeals to think about what justices you want to essentially have the final say on any cases that are tried here in Tom Green County, as well as those other 23 counties that are in the Third Court's jurisdiction. Over 90%, well over 90% of the cases that are appealed to the Third Court aren't further reviewed by the Texas Supreme Court. There are some cases that don't go to the Third Court, so I think most prominently death penalty cases don't go to the Third Court. The other thing I would say, excuse me.
Hello.
The other thing I would say, just to wrap up on how to think about the role of the Third Court, is it handles a lot of government cases. Cases involving state law, cases involving state regulations, cases involving state actors. If you remember back when Governor Perry had a criminal indictment put in by a Travis County grand jury, that was appealed to the Third Court. The Third Court gave Governor Perry and his lawyers a first major legal victory that they achieved during that prosecution. Lots of cases involving Texas state laws and actors go to the Third Court because Travis County, the seat of our government, is one of the 24 counties. So again, just to sum up, when we think about the Third Court, cases on appeals across many issues, as well as in particular the government cases that come up in Travis County are the main function of the court.
Okay, well, Mike did such a great job of describing what the court does. Let me tell you who's on the court now and a little bit. I've learned a lot because David Purrier, Cindy Borland, Scott Field, Melissa Goodwin, and Jeff Rose have constantly been at different events where we've been. And here's the importance of November. Just like Mike was saying, each one of the places has a Democrat opponent. I believe it was David Purrier who said that the entire percentage of victory between a win and a loss for a Republican was 52% to 48%. With Tom Green County, sometimes we don't know, nobody knows who's the winner until everything gets counted. With all those counties, I mean, Schleicher, Irion, Mills, McCullough, I can start naming them all, Coke, Concho, they don't have enough votes to overcome Travis County by themselves. So with Tom Green, Comal, Bell, Williamson, and we have to get a good portion of Travis in the November election to win. You need about 40% of the vote in Travis County to win. It is very easily, they smell blood in the water. They think that they might be able to ride a blue wave, and we've got to keep them pushed back. For those of us who've been doing this since Ronald Reagan inspired us a long time ago, you know, we need to make sure that we do not get complacent. We need to make sure that we get the right nominee on the ballot to win and to neutralize the Democrats, because they are really, like I said, they're like sharks in the water and they smell blood.
Thank you. We're gonna try, well, let me try this again, because I really. Can,
Yes.
I hear me, okay, thank y'all, thank you for being patient, candidates and audience. The next question is again addressed to both of you, and I guess we'll just alternate back and forth, okay? So whoever's first goes last and vice versa. But anyway, this question is, how does the Third Court of Appeals affect us here in Tom Green County?
As Mike had mentioned, all the state agencies are based in Travis County. Well, even if something happens here in Tom Green County, but it relates possibly to a state regulation or a state law, it will end up getting appealed in the third court. So it could even be an election law case that ends up going. For example, I've done, in 2016, I had 6 recounts and 3 election contests. So when those kind of things, if there is a recount and you did or didn't win, was everything counted right, properly, a district court has to make that decision. But then if you appeal it, that has a direct effect on you. A lot of people don't think of an appellate court as having any kind of effect on their life, but as Mike well stated, because it is a court of right and anything that is appealed from the 24 counties comes back, that provides precedence. That provides an interpretation so that future cases will be decided along those same lines, as long as everything was done appropriately the first time and something's not unconstitutional. But that has an effect on everybody's life. Anybody who's appealing, if they were, I'm not going to pick on any dentists in the room, but if somebody were charged with not following all the codes in the dentistry statutes and they started to appeal or tried to accuse, that does directly affect y'all.
Wonderful. I'll just add a couple things. First off, if you live here in Tom Green County and you have a court case and there's an appeal of the court case, it'll come to the Third Court of Appeals. So if you have a business or if you have a claim or if you have a contractual issue or you have a property issue, if you have really any legal issue that ends up in litigation, the appeal would be handled by the Third Court of Appeals. So that's point one. And then point two is back to the government. Think about what your legislators are doing. Think about what Representative Darby and Senator Perry are doing. Think about the votes that they're casting. Think about the laws that are coming out of Austin after the regular sessions and the special sessions. If those laws are challenged, typically the appeal is to the third court. Typically that's where the case ends. So think about the priorities of your legislators, the priorities of the lawmakers that you put into office. Think about the priorities of the statewide elected officials who run the various agencies, whether it's the Attorney General's office, the Railroad Commission. Think about the folks that you read about, that you follow in positions of leadership across Texas. Their priorities, their initiatives, when they're challenged legally, and I'm not going to say whether these challenges are good or bad, but just as a practical matter, when they are challenged, the third court is the court that ultimately handles those cases and sorts out the legal issues around them. So that's why the third court is so important. It really is the court that is handling so many of the government's priorities when they go to court across the state of Texas. And those laws and rules and initiatives and priorities of the statewide elected officials, of course, they affect San Angelo, and that's why y'all, everyone here takes such an interest in what your lawmakers and what your statewide leaders are doing. But when those cases go to court, they tend to go to the third court.
Thank you. Okay, next question, again addressed to both of you. Did your law school studies focus more on case law or constitutional principles?
A little bit of both in my case. So I focused on the Constitution while I was a law school student, and I took as many constitutional law classes as I possibly could and still get a law degree at the same time. So you have to take a variety of law school classes in order to get your JD. But with any elective that I had, I tried to take courses that prepared me to understand and deepen my appreciation for our great Constitution. Now, some classes tend to focus more on case law, so contract law and property law, and a lot of the quote-unquote common law courses that we inherited from the Anglo-American legal tradition. So much there is not set by legislators, by regulators, but it's set by court decisions that involve principles which future courts apply in the cases that come before them. So in those areas, I would say that much of the course would focus on case law and the development of case law and the development of the doctrines around those case law. And that would be, it's hard to quantify exactly percentage-wise or time-wise what part of my law school career that constituted. That would be some part, but then the other part, and frankly the part that most interested me, were the part that dealt with our Constitution and dealt with constitutional principles from the time of our founding to the present day.
At the University of Texas School of Law, where I went to school, you were required to take constitutional law as a fresh law. I got to learn under Charles Allen Wright a lot about the Constitution, but it was only for one semester. So when I finished with that as an honors student, which I was so proud of that because he was such a great professor. I tried to seek out another constitutional law class, and the only other one was offered by Lino Grazia, and I got to take that, and he focused on constitutional interpretation, Brown versus Board of Education. So I got to learn a lot under his teachings, and then I thought, well, you know what? After taking those kind of classes, I need to see what the government does interacting with it. So I took an administrative law course so that I could understand how the administrative law in the executive branch works, because in state agencies and in federal governmental agencies, and especially way back when I was in law school, you guys, it was quite a while ago, they actually back then had the administrative law judges in the state agencies. The State Office of Administrative Hearings didn't exist back then. So in some state agencies, you'd actually have, like Commissioner Perry, when I worked for him at the Ag Department, he was the judge over pesticide enforcement cases or over, weights and measures cases, because I don't know if you've realized this, but all your gasoline tanks and everything, it says Sid Miller's name on it. That's because weights and measures fall under the Department of Agriculture. So you'd have the administrative law judge there. You'd also have the enforcement people there. And they would be implementing the rules. So it's almost like you had an executive, legislative, and judicial branch in this administrative agency. And that was something that I focused on as well, because how do you deal with the Constitution with that? Not all of those members who head agencies are elected office holders. So it becomes a very interesting issue. So that was my focus, because I knew I wanted to go into public service.
Okay. The next question, again addressed to both of you. Where did you earn your undergraduate and law degrees?
I earned this gray hair honestly. I graduated from the University of Texas with a Bachelor of Journalism. For those Aggies out there, I love Aggies. I only have Aggies as my vets for my dogs. But I got that in do I have to say the year? No. How about I went to law school later
And that was in 1992 that I graduated from the University of Texas School of Law.
I went to Stanford University and I studied history. And I think the highlight of my time at Stanford was I was the editor-in-chief of a conservative newspaper at Stanford University. And thank you. It was an interesting experience, I'll tell you that much. And I found out who my friends were real early on in my educational experience. I went to the University of Virginia for my law degree, and I got a master's, as I mentioned, in history there. I chose UVA for a couple of reasons. When I was applying for law school, I got a brochure from UVA, and it included a kind of a memoir from a much older person who had gone to UVA, and he applied after service in Vietnam, and he said that a lot of law schools, weren't really interested. They didn't really see what he had done defending our country in Vietnam as public service, but UVA did, and it had a very strong tradition of public service, and had some great professors. Also, I knew going into law school that I wanted to do this extensive study on constitutional history, and UVA offered this opportunity to do a joint program where you could study law and history at the same time, and I found that to be very fruitful at the time and continue to this very day. I mean, it's so important to understand the historical underpinnings of our Constitution, and it's such a rich source of knowledge and wisdom about the great virtue of our government.
Thank you. Okay, again, addressed to both of you. Which carries more weight, federal law or state law?
Well, I think it depends on the issue. Our Constitution, the U.S. Constitution gives enumerated powers to the federal government. And so beyond those powers, the federal government doesn't have any authority. So whatever power we gave to the federal government, because ultimately all power in the United States comes from the people, and we gave our federal government the authority to do certain things. So I'll give an example. Immigration law, federal immigration law. If a particular state wants to have policy on immigration, the U.S. Supreme Court has made it clear that the federal government is responsible for federal immigration law. And this is a point that's being litigated right now. And the Texas Attorney General's office, where I work, has made it very clear that the federal government, in issues like sanctuary cities, in issues like the border, the federal government has the authority to use its constitutional powers on areas where there is a real national interest. And the position of the office has been individual states, their opportunity is to go to Congress if they don't like the policies of the federal government on this issue. And their role is to try to convince Congress to go a different direction. And our system allows them to do that. It doesn't allow them to have their own immigration policies or foreign policies. On the other hand, the Constitution that we have is not a national constitution, it's a federal constitution. And what that means is the states remain laboratories of democracy. The states remain the main avenue and energy for education, for healthcare, for a whole host of issues that the federal government under its constitution doesn't have an enumerated power.
Well, way back in law school, we learned that, and like Mike said, it depends. So let's say you're just trying to figure out what ranks where. Generally, the United States Constitution obviously is the law of the land that everything is looked to as far as federal statutes, as far as our freedoms. The 10th Amendment provides that anything not given to the federal government is reserved by the states. So then you go down to the Texas Constitution or whatever state you're in, and you come down the way with the statutes, and then you start going down with the rules or ordinances down at the municipal level. So what trumps generally depends on what the issue is. We don't deal with a lot of federal issues. It's a state court. So it's intended to deal with state issues. There could be a constitutional issue that has federal implications, it probably would be transferred out of the state system into the federal system so that it can go through a federal district court to then the Fifth Circuit and then to the United States Supreme Court. So it really does depend on what the issue is, what you're looking to, and how you would go about interpreting it from there.
The next question, again addressed to both of you. How long have you been licensed to practice law in Texas?
I have been licensed to practice law in Texas since November of 1992, and I'll tell you a little story. I was working at a water law conference trying to get some experience there, and I had already done some legal work prior to that because I was a third-year law student and I was at the agriculture department, and back then we couldn't look online to find out if we had passed or not. So what did my husband do? He called me and I said, "So did you find out?" And you know what he did? He said, "Well, I've got some news for you." I thought I had failed, but I passed. Got him later for it, but I did pass on the first try, the state bar exam that was administered that summer. So yes, November of 1992 is when I've been licensed in Texas.
I graduated law school in 2006. I was a commissioned lieutenant in the Marine Corps before I went to law school, and I was on a JAG contract, so I was obliged to do military service as a military attorney. Military attorneys are required to have a state law license in order to adequately represent our service members. Doesn't matter what state law license you had. I had a hard time thinking about where I was going to end up when I went on active duty because military life is very transitory. I didn't know where I was going to be stationed. It's the Marine Corps, for heaven's sake. They don't guarantee these kinds of things. So I didn't really know what to do in terms of what state bar to take. And I talked to a law professor once. He said, make the decision that makes the most sense for you right now. So I looked at the state that had the most amount of reciprocity with other states. So some states will let you waive in if you have another state bar license. So New York had the highest amount of reciprocal privileges. So I took the New York bar and I passed it, and I practiced in the U.S. Marine Corps with the New York bar license. I got licensed in Texas 2 years ago to work at the Attorney General's office, obviously representing the state.
Thank you. Again, for both of you, does the court ever come to Tom Green County to hold court?
That's a great question. It's an appeals court, and courts can travel. And I know that the third court has traveled recently. I think it was up to Bell County, if I'm not mistaken. Okay, and they've come here too. So in any case, it appears like the third court has come to Tom Green County and can come to Tom Green County. Little detail on appeals courts. You oftentimes hear appeals courts referred to as circuit courts. And the reason for that is the justices used to ride circuit. When I mean ride, I mean like on horses. They would go around and they would ride around the circuit that they were assigned to. And that's how that name came about. So in this day and age, I don't think it's a requirement to actually get on a horse and ride. But certainly you can come out to different areas that are within your district.
So the answer is yes. I think Jeff Rose at one of our candidate forums was talking about how they made a concerted effort to try to come to Tom Green County, and there was a new facility in Bell County, which is basically where Salado, Belton, Temple are, and they wanted to make sure that they were amongst the people. So I think if there's money, and of course it really does depend on budgetary constraints. Jeff Rose is the Chief Justice and he handles all those administrative type matters. So if it were possible for them to come back out, I'm sure they would try to do that if it's within their budgetary limitations. You have to follow budgets and rules of law, right?
Okay. Another question again for both of you. How would you interpret from the Second Amendment, shall not be infringed? Do you feel that any certain firearm should or could constitutionally be banned?
Okay, that's a really interesting question. Let me start with a little story. My daughter went to the senior prom, and one of my husband's friends said, "Did you have the shotgun out?" And he said, he posted pictures of her when she was little, when she was medium little, and now that she's big. shooting. And we said, you don't have to teach, you don't have to worry about her because we've taught her how to take care of herself. Now, what does that have to do with the Second Amendment? We would probably not get that case, but if somebody were to challenge the Second Amendment in court, under the rules of the judicial canons, we can't say how we would rule and we can't say if we agree or not. But I will say that the Constitution is an enduring document and the Constitution should be abided by. And I think it would very much depend on all the facts, and I don't think that case would ever come before the Third Court of Appeals.
You know, one of the great hallmarks of the life of Justice Antonin Scalia is the Heller decision. And the Heller decision, I mean, if there's something you can do to just gain an appreciation of Justice Scalia and his legacy, it's that decision. And the Heller decision upheld the individual right to bear arms under the Second Amendment of the United States Constitution. And it really is a tour de force of judicial reasoning. And it's a great opinion because it encapsulates everything that Justice Scalia brought to the United States Supreme Court and the American legal system. Justice Scalia was an originalist. And so what he does in the Heller decision is he applies that methodology to the Second Amendment. What is the original meaning of the words in the Second Amendment? And it really is the greatest example from Justice Scalia of this methodology that he brought to the United States Supreme Court. And what a great country we live in right now. The influence of Justice Scalia remains so great on our legal system. I mean, if we go back and you read opinions before Scalia, it is a totally different process. Courts oftentimes wouldn't get to the text of the Constitution or of the statute. And Justice Scalia just turned all of that around. And he made opinions accessible. He made opinions documents that could be followed and understood by the people who are governed by our leaders that we put in office. My opinion on the words of the Second Amendment is, as Justice Scalia laid out in the Heller decision, they should be given the original meaning that they had. As to particular pieces of legislation that may affect the Second Amendment right, of course, the last thing that anyone running for judicial office wants to do is put him or herself in a situation where they can't hear a particular case because they've indicated to individuals how they would rule. In that instance, the person would have to recuse him or herself. So the judicial canons serve to protect the public so that the officers that you choose to put on courts are able to hear the cases that come before them.
Did both of you respond to that? I'm sorry. You both had a chance. All right. The last question that I have collected up here is addressed to you, Mr. Todd. What is your stand on sanctuary cities, immigration of foreigners, and Trump's wall?
Right, well, you know, my opinion about different issues really is that what matters is what the law allows those that are in office to do. And so at the Texas Attorney General's office, I've worked on a number of the items that we've talked about, such as sanctuary cities. And what our office has always made clear is that our involvement is not to advocate a particular policy or to advocate against a particular policy. It's to point out where legal authority lies. And so I'll give an example of this, and it's along the lines that you mentioned in the question, the travel ban. So President Trump issued a travel ban. And when the first travel ban was issued, there was one state which filed an amicus brief supporting the federal government's issuance of the travel ban, and that was Texas. I remember the Texas Attorney General, my boss, went on MSNBC and was asked, "Don't you feel lonely?" He said, "No, I represent 28 million people, I don't feel lonely." By the time the travel ban made it to the United States Supreme Court, it was argued in late April. Texas was joined by 15 other states, a total of 16 states. Now, as for the travel ban, there have been 44 uses of the travel ban. Congressional law makes clear, and the Constitution behind it, that the president has the authority to issue travel bans, and even issue travel bans that point out, that treat different nations differently, based on the situation of those nations and based on our interest in the United States. Now, that's not to give the personal opinion on whether or not a particular travel ban is a good idea. What matters to the Attorney General's office, what matters to me as a judicial candidate, and what would matter to me, and the only thing that would matter to me as a judge, is does the law allow it or not? The decisions as to whether it makes sense or not, those are decisions for you as citizens to make up your minds and to be talking with your elected leaders, whether they're in the executive or the legislative branch, to give them your views, to inform them. And that's where those decisions are made. What courts are really there to do is to answer the important question, is there the authority to do this or not? And that's where I have spent my career at the Texas Attorney General, is on those types of questions.
Thank you. So now I do have some more questions collected now, and this one will be addressed to both of you. Would you say we now have a democracy rather than a republic? If not so, why do we hear the majority of references to our form of government as a democracy?
I like to think of ourselves as a constitutional republic, but I actually looked all this up because I was interested in finding out definitions. I found out that a politician, which I don't think of myself as, I actually am, according to the definition, because I'm running for office. That makes me a politician. So when people who are running for office say, I'm not a politician, technically, that's incorrect. Insofar as the constitutional republic, apparently, according to different sources, it's a form of a democracy. However, in my mind, because it's a representative form of government, because it is a constitutional republic, I don't think of it in so far as democracy by gang rule, obviously. How many of y'all go to church? How many of y'all are Baptist? How many of y'all are Episcopalian? Presbyterian? Catholic? Okay. All right, so did you know that there are representative forms of government? There's an Episcopalian form of government. There is a congregational form of government. Generally, Baptist churches are congregationalists. That's not what we mean by a constitutional government. That's not what we mean by a democracy. Most Baptist churches are autonomous, and they actually, the members make all the decisions. In the Catholic, Methodist, Episcopal, Presbyterian, not Presbyterian in this instance, in those other denominations, there is a board, there's a governing board that goes through. In our United States of America, we value freedom. We value the Constitution that enumerates what limitations we have. Otherwise, we're free. And that's what makes a big difference. And some people like to say that that's a democracy. I like to call us a constitutional republic. But if you look it up, I think it's also defined as a democracy.
One of the great virtues of our government is representation. And our government is really built upon representation. It's built upon individuals who represent you, being elected by you, and being accountable to you at regular intervals and regular elections. That is the design that our framers put into place. I think where we've gotten away from that design, power has been delegated to unelected and unaccountable individuals. And then it starts to look less like a representative form of government, because those that represent us and have the lawmaking power seem to be further and further and further put onto the sidelines. I think also I would say one of the issues that really undermines the rule of law is when you have public officers say, well, you know what, I know I can't do this, but I'm going to do it anyway because the people want it. Because the people want it. And there's a couple problems with that. Well, what if the people don't really want it? I mean, who's to say that particular individual really knows what the people want? I mean, how is that determined? Is there a poll? Is it an educated guess? Is it the right of that person to tell us what the people want? So where does that decision get made, and how does it get made? And then, of course, there's the principal problem with that also, which is our form of government is based on what legal authority do you have to make decisions. And that ultimately is a standard that we all have to live up to. And again, that's the vital role that courts play. It's determining the lines of legal authority our elected officials in government have to play by.
A lot of conflicts. How do you go about making the final decision? And do you consider the Constitution as a standalone or as an important part of our founding documents?
I guess I'll take the second part of the question first. I think our Constitution really stands apart as the document that establishes the federal government. Now, to understand the Constitution, it is very important to look at the documents that existed also at the time of the Constitution, to get into the minds and to get into the shoes of those that framed the Constitution and the American people that ratified the Constitution at that time. If there's a conflict between the Constitution, between the clear text of the Constitution and what a court has said, then the responsibility is to apply the constitutional law. And this has come up time and again in our country's history. And I think also, I referred earlier to the Heller decision. And the Heller decision is a great example of this. There are cases that dealt with the Second Amendment, but what Justice Scalia did in that fantastic decision that I mentioned before is he went back to the words of the Second Amendment. The Constitution is the ultimate precedent. The Constitution is the ultimate source of authority. And so you have to understand the words of that constitutional text that came up in that case. So the thrust and the energy, the dynamism of the Heller decision is based on the words of the constitutional text. And in doing that, what Justice Scalia and the court did in Heller, and this is also true in other decisions that have come recently, is turn us back to the document that we have to stay faithful to remain the country that we are.
As to the United States Constitution, I think that because of its significance and importance, that it does stand alone. So I would agree with Mike. And if there is something that actually conflicts with it, some sort of statutes, let's say there's some state statutes that get passed that conflict with the freedoms that we have through the United States Constitution. Let's say there's no conflict with the Texas Constitution. Let's say there are other statutes out there that you have to kind of look at to see, okay, how has this been determined before, case law wise? Are there similar cases? Are there similar laws that have been turned or ruled as unconstitutional? You look to case law with it, but it is part of a whole process. You need to love to read, you need to love to research, you need to love to work puzzles, because you're trying to figure out how all the pieces fit together. And then you have to make sure that it is reasoned and sound. Because probably 50% of everybody is not going to like the way you come down on a decision. 50% will like it and 50% will not. But you have to know why you came up with that decision. And the Constitution is definitely what sets us apart from other countries in the world. The Constitution is what we need to abide by, and then we need to be brave enough to defend the Constitution by ruling laws that are unconstitutional such.
What are the biggest changes you think we need to make to our justice system?
That is a huge question. In going out and talking to different people, a lot of folks are trying to make it more accessible. I'm not really sure how we can go about doing that. I know that there are, the Texas Supreme Court, the Texas Court of Criminal Appeals works with the state bar, and they try to go out and find what these issues are to try to make it better. So what are those issues? A lot of times people are too poor to access the legal system. So pro bono and legal aid services are oftentimes provided and encouraged by all lawyers. I know that there have been people in my life that from church could never have afforded a lawyer, and I've helped walk them through different things because they needed to get access. And it never resulted in a court case. Sometimes you just need legal counsel. And so I think trying to help us all serve one another officially, I never even report my pro bono hours. I don't keep track of them because I don't want to worry about that. I want to worry about helping people. So I just help the person that comes next, or the person who maybe needs help drafting different documents because they have cancer, or whatever the situation might be. But I think legal access is one of the difficult questions because it takes money, it takes know-how, and it takes access to those lawyers that can help. And I'm not sure there's an easy answer. And I hope that if I am elected at some point, I get to serve on one of those boards and commissions, because when I was growing up, I remember having to go to the free clinic just to get some medical care. I did not have my teeth even checked until I was almost 9 or 10 years old. And I never went to a dentist, a proper dentist, until I was 28 years old. So sometimes legal issues are about the same way as trying to access medical care. And I think those are societal issues that the churches and those who volunteer and those who are community-minded can help with, until such time as, I don't look to government to go fix it. We've got to try to come up with some ideas. And I'm not sure I've identified anything particular, obviously, but just in general, that's the way that I feel it should be approached.
Yeah, Donna made some great points there. Obviously this is a big issue, and access is a huge part of it. And what Donna said about churches and civil society, just people reaching out to other people through the clubs and the associations and the organizations that they're in, is such an important part. I would just say a couple particular things on access. I really think that our judicial system has an obligation to make things clear, straightforward, user-friendly. I'm talking about the forms that you have to file. So, the average, ordinary, hardworking person can have a roadmap as to how they need to interact with the court. I think that's very important. I think that's important all across our state. I think there needs to be a little bit of attention on mental health issues. The Third Court and, the Texas Supreme Court and the Court of Criminal Appeals have taken a particular interest in that issue as to, are there better ways for courts and for lawyers to be thinking about mental health issues that oftentimes come up in cases, and they really are a big part of the case, but maybe we're not focusing proactively on ways that we can improve the situation there. The last thing I would say is, in terms of representation, I'm not fond at just throwing money at problems as kind of the first course of events or first order of business. I think when we think about adequate representation of clients on appeal, there's so many lawyers, so many young lawyers who are eager to actually get into a courtroom. One of the changes in legal practice over the past few decades is just less and less litigation, or less and less time in court. More litigation, but more activity outside court. And there's lots of lawyers that, it's hard to express this, but can't remember the last time they were in court, or it's been a while. And a lot of young lawyers have a hard time actually getting into court, and they're talented. And I think as a profession, and the courts have a role in this, we could do a much better job matching up individuals who need really good legal representation with lawyers that are very talented, that are eager to represent someone in court. So I think that is something that we can do a much better job as, and if we do that, I think we'll provide much easier, skilled access to our court system.
What is your view of swift judgment? Laws have lost their teeth on discouraging crime if it takes years to judge.
Right, I think obviously the two biggest roles of courts is get it right and get it done. And there's a little bit of tension between getting it right and getting it done, because sometimes getting it right takes a little bit of time, but we also need to get it done. And particularly in context like the criminal context, where the community is so affected by the decisions that the courts are issuing, it really is important for the courts to look at the facts, to look at the law, to understand what has happened, and to issue a decision as quickly as they can while still getting the decision right. Too often, I think, in our system, we have cases that go on and on and on and on, and even the parties don't really know what the next step is going to be. So I think it really is important for judges to make it clear and make it straightforward as to what the next steps are. I had experience with 2 different federal judges, and one thing that they really shared in common, one was a trial court judge and one is the appeals court judge I mentioned, is they like to work quick. You know, they wanted to understand the issues, they wanted to roll up their sleeves, they wanted to work hard, and they wanted to issue a decision so we could move on to the next case. And one of the things that I learned is that one of the positive benefits that courts provide when they're doing their job right, when they're staying in their lane, is they settle matters. And, you know, as Donna said before, you know, 50% of the people may not like the particular settlement, but I think what we can all appreciate is that the matter is settled in that particular case. And we can get on with things. It may not be a perfect picture, and it may not be to everyone's liking, but I think we all benefit from a case that's disposed, that's been handled, and we can move on with things.
So, I know that everybody's heard that the wheels of justice turn slowly. I think there's been a concerted effort to make sure that it's not as slow. And part of the reason is because of the frustration level, I mean, and the costs. The longer it takes, does it cost more? It costs more in time, it costs more just in general trying to work things through and get it settled. Closure is always a good thing. So I think, for, like Mike had said, we need to be cognizant of getting it right, not just accomplishing it. And in this day and age when everybody wants instant gratification, it cannot happen that quickly. But, you know, I'm not saying we should be the tortoise, and I'm not saying we should be the hare. I think we should kind of be in between and make sure that we've got what we can process more quickly done more quickly. What takes a little while longer, get some help, get a couple of your colleagues to help, and get it done through that collaborative effort more quickly than one justice would be able to on their own. There is an allotment of cases, I believe, to each of the 6 justices, but it doesn't mean that you have to be an island and you can't talk or get some help. If it's an area in criminal law that somebody might have an expertise in, or if it's an area of administrative law that somebody else might have more of an expertise in, I think the collaboration on the 3rd court is conducive to getting things done. If I recall Chief Justice Rose saying that they have actually been able to get the cases finished and done on a very timely basis. I don't know that they won any awards for it, but it's definitely been something that everybody's cognizant of and is working hard to make sure things are not just out there for a long time.
What is your opinion on state licensing laws of gun owners? Would these cases come before you or before the Supreme Court? And then examples of 30.06 and 07 restrictions. How can they stand on the Second Amendment?
Okay, that's really interesting. The 30.06 and 30.07, I guess, is in the licensing statute. So not having it in front of me, I will say that my husband was the committee clerk for the Committee on Public Safety when the concealed handgun licensing all went through. I'm slightly familiar with what those rules are, but he decided not to become, and he could have become a teacher, but he didn't. So I never had to go and follow up on that to advise him on things. So I'm not as familiar with that, and I will readily admit that. And so far as what do I think of the regulations now, I am not as well versed on those particular state regulations at this point. I know that we've got our guns and we've been able to do everything we wanted to do, so it hasn't been an issue for me. And insofar as the Second Amendment that allows us the right to bear arms, then the United States Constitution would help with eliminating some limitations that might be incurred. But if there's a rational basis, there's constitutional interpretation that takes that into account too. Is safety and welfare an issue? Is it maybe a regulation that if you've been in a mental hospital, you might not be able to be licensed? What is the rule? And I apologize that I don't know those particular provisions right off the top of my head. But something that would be a state regulation or a state law would likely come through the 3rd court, so I can't say how I would rule, but I would say that I would look at everything that was available to me to figure that out.
As I sit here now, I suppose I could contemplate a case involving 30-6 or 30-7 coming to the third court, and that has to give me some.
30-6, I'm sorry, my husband said, I'm sorry. I hear it now, I'm sorry. If you had said 30-6, I would have, oh, okay.
I'm sorry.
Okay, no problem. I thought she was citing something. My apologies, and I didn't mean to interrupt you, but I'm like, I know what a 30-6 is. Okay, sorry.
But I'll be brief on that. I mean, I think there is a real possibility where implementation are the kinds of cases that the third court regularly hears, across a variety of different issue sets. So it's not just necessarily gun licensing, it could be other kinds of licensing cases. These are the kinds of government rule implementation kinds of cases that really, in a lot of ways, sets the third court apart from the other courts of appeals across Texas. So bear in mind, in Tom Green County here, obviously within the third court, you are a part of a very special state appeals court, because you're a part of the one that really has the opportunity to issue rulings on these cases that involve major state rules and major state laws and state licensing regimes and things of that sort. Folks in Dallas and Houston, they're involved in different state appeals courts. And those courts are very important, but they're different because they're not always handling these kinds of government cases. They're handling cases that come on appeal from the district courts in those jurisdictions, and they may be important cases involving businesses and involving property rights and involving other matters. But they tend not to be as focused on the priorities and the laws and the rules that your elected officials are putting into place. All that said, since these are the types of cases that come before the third court, I'm worried as someone who's running for the third court to say exactly how I would rule in a particular matter that would come before for the reasons that we've talked about before.
I do apologize for reading that wrong. So,
I should have heard it. It's okay.
well, Mrs. Davidson, since that was my fault, is there any comment you'd like to add to that? I'm sorry, now that you know.
My husband's gonna kill me if he does. Anyway, no, I'm good.
I apologize. Oops. Okay. Again, to both of you, the county is paying for indigent legal fees, which causes our taxes to escalate, especially in murder cases. Do you have any ideas or solutions to this issue?
As I mentioned before, we were talking about access for justice. My first inclination with any issue is not to throw money at the problem. And I really do think, again, in our legal system, we have constitutional rights for adequate representation. Courts have to be impartial, and the system has to be set up fairly. So, the parties go in and they're on equal footing to present the facts and the law, and the court isn't on one side or another. That is really what sets us apart as a country when we think about our criminal system, when we think about our civil system, our civil justice system, criminal justice systems. All that said, I think there are ways to provide for adequate representation for lawyers that match up individuals who are in practice, who are looking for ways to make a difference, to make a positive difference, to get into the courtroom. And I think we really should look for opportunities to better facilitate this sort of matching process. And I think in those cases, I think we really would find that individuals are getting the adequate representation that we have a constitutional right to have. I think further, we need to better facilitate conversations between the trial courts and the appeals courts as to what types of lawyers are really providing quality representation to their clients in these kinds of cases. I don't think in the current situation that there is as much communication as there could be between the appeals court and the trial court about the quality of representation of individuals. So I think all of that is important, but again, I don't think throwing money at a problem, even a legal problem, is necessarily the only way to solve it.
I can say over my 25 years of practice, I've seen a lot of differences and I've seen a lot of changes. And when I was in the governor's office, I was basically the person that would tell the warden to proceed with an execution. That was after I had briefed the governor, after I had reviewed the entire case file, after we tried to make sure, was there adequate legal counsel, was there not, were all the I's dotted and the T's crossed. Everybody's probably heard of the Michael Morton case where he was innocent and then it took a long long time. He was in Williamson County. He had been accused of killing his wife. Somehow the DA had suppressed evidence, and there was some DNA evidence that was later found. I don't know all the details of it. I didn't follow it that closely, but I do know that there is a lot of attention being given, especially since we used to be a death penalty only state. We now have life without parole, which was not an option back when I was in both Governor Bush and Governor Perry's offices and helping with basically executing the prisoners that were on death row. So I take this very seriously. I understand that there are questions, there are groups out there that have gotten together. Part of the reason we do now have life without parole is because they have found mistakes in the process. And as we continue to try to get the process better and better, we need to make sure that no one innocent is executed, but we also can have some confidence in the legal system. Like Mike, I don't believe in throwing money at the issue, but I think there are several different organizations that are helping to address this. And through that and through what the Supreme Court does in the Court of Criminal Appeals especially, because it's their area, I think that we can get, and we continue to get better. They are talking about some different things to provide for lesser costs maybe for DNA, for other things that could result in more exonerations instead of the witnesses that maybe have a faulty perspective. So hopefully I answered the question.
Why are you a better candidate than your opponent?
Okay, the question was why am I a better candidate than my opponent? I will just say I am a different candidate from my opponent who would be able to take on Gisela Triana in November. Gisela Triana has been licensed in Texas since 1988. I've been licensed in Texas since 1992, pretty close. I have gray hair because I'm older than she is. She has 5 children, I only have 1. That's an aside, but she is actually putting on her website that she will be the first Hispanic on the 3rd court if she gets elected. That is not a qualification at all. I heard Melissa Goodwin say that by being female, you get 5 to 6 extra points. Okay, that is not a qualification either. I've also been told that being the first name on the ballot gives you 5 or 6 points. That is not a qualification either. But if you take all of those into account and you can diffuse the Democrat surge, if you can neutralize what they are going to try to do, because do y'all remember how we got President Obama in the first place? The Democrats were out, the independents were out, they wanted to make history. And what was the history? To have our first black president. Does it matter that I'm Hispanic? No, but it doesn't and shouldn't matter that she's Hispanic either. I do think that I am the best qualified candidate to go against Gisela Triana and to neutralize the Democrats from getting energized and enthusiastic about things that don't make a whit of difference. And if we can do that, I think we can keep the court. Otherwise, I think she's going to be able to raise unlimited amounts of money. She is not under the campaign finance laws that apply to other judicial candidates, and she'll be able to raise as much as she wants. I can raise as much as I need to as well, so we need somebody that can combat that in the fall.
Well, I appreciate the question. I don't have anything negative to say about Donna. I'd say we've been campaigning for, I don't know, 7 months now. It seems like it's only been 7 days. It's been a real enjoyable experience. Not just meeting the voters, that's been obviously a great aspect, but also, getting to know the other candidates. And I'll say publicly, Donna has always treated me very graciously. Not just that, but also my volunteers. So I have Patrick here, and we drove together from our neighborhood, and I watched Donna not just interact with me, but also the folks that have been helping me out. So this isn't about, what Republican candidate needs to beat up on what other Republican candidate. I mean, we're both here because we believe in you, we believe in our Constitution. What I'm running on is my qualifications and my experience. That's it. I'm not running against Donna. And I'm running because working at the Texas Attorney General's office and working for a couple federal judges and serving our country, I really saw, what's at stake with our constitutional values, with our system. And I think for a while the battle was really with the executive. I think that battle's moved to the court. And what I'm hoping to do is to take the experience and qualifications I have and to bring those into judicial office. I'm going to run as hard as I possibly can. If I'm fortunate enough to get enough votes in the May 22nd election, I'm going to keep running as hard as I possibly can in November. And I'm going to turn over every single stone and do everything that I possibly can. I feel really blessed in the team that I've put together. When I served in the Marine Corps on active duty, one of my first buddies was a graduate of Texas A&M, and he said, at A&M I learned you don't have to be the best, you just got to be around the best.
There you go.
And I've tried to implement that, and I have a number of folks who have gone behind me. I mentioned Senator Perry, but also Julie McCarthy, Kathy Adams, Grassroots America, We the People. I mean, there's so many great groups and people. And I'll just end by saying this, I really have been inspired by the folks that have gotten behind me, and I think they're the best, and they've also wanted to make me the best candidate that I possibly can be. And I promise you, if you vote for me next week in early voting or on May 22nd, I'll continue to work as hard as I possibly can for you and for all Texans.
Semper Fi.
Thank you. We still have a few minutes left, so I'll give you both of you the opportunity to make any closing remarks that you would like to make. If there's anything additional you'd like to say.
Thank y'all for having us. This is always a delight. It is a little bit of a drive, but I got a hotel room this time instead of crashing at the Bartosh's without notice. The rodeo was in town last time and there was no room to be there, so got to take a nap before I came over, and this is good stuff. So thank you for having us. I love being out in this part of Texas. Mike is a delight to be running with on the ticket. Republicans not being divisive is something that we need to model more of. If you remember back in the old days, and actually I was telling somebody the story, in 1984 in Travis County, we had to have a rump convention just so pro-life candidates could be put on the delegate list to the state convention. That was back then. Now we've grown. We've got wonderful conservatives that have been working for more than 30 years like myself, and then we've got relatively recent converts to conservatism, and they're working alongside. I think it's fabulous that Tea Parties exist, because I almost feel like I was Tea Party before there was a Tea Party. Of course, having worked for Rick Perry, that makes a difference too, because he's one of my endorsements. And just so that you know, other than Rick Perry's endorsement, I have Wayne Christian's, Sid Miller's, Glenn Hager's, Senator Brian Birdwell, and I noticed Rick and Kara Green's book is out here. I've got Rick's endorsement. People who've known me a long time because of my record are supporting me, and I would just humbly ask for your support. Please go to my website, Donna4justice.com, or pick up some materials from me. Do the research, find out who you believe should be the candidate, and I think that we can win in November. We just need to make sure that we're all working hard and together. So whoever the nominee ends up being, we all still need to be the same family, because we are the same family. So I'm Donna Davidson, and I ask for your vote on May 22nd, or early vote right after Mother's Day. Thank you.
Well, I'll just close by just again thanking everyone for having us, for being here, for being back. We did this before the primary, and it's great to see so many folks again. I always think that y'all must love legal issues so much to come and listen to two lawyers talk about abstract legal concepts, and so I do really appreciate that. I've certainly had moments with my own family where talking about things like the political question doctrine has led them to flee the room and not return my phone calls. It did have one benefit when I was taking care of my young nieces and nephews. It would put them right to sleep. So it's great. It's great. I appreciate being here. I appreciate y'all being here. And once again, I mean, one of the great virtues of the Tea Party movement has just been focusing on first principles, focusing on what we're about as a people. You know, we're about our Constitution. That's why we're the greatest country in the world. And I think if we can continue to present and represent to all Americans and all Texans what sets us apart. And what sets us apart is at the beginning of our country, our framers and our founders got together and they framed a government that matched human nature, took the world as it is, and it's protected and preserved our liberties over 200 years since then. We need to keep that in place. That's why I want to be a judge. I see how important courts are. And once again, I'd be delighted to have your support in May, and I'd be delighted to have your support all the way through to November 2. Thank you very much.
Thank you